Good afternoon. My name is Jess Lewis. I am the Program Supervisor for Foster Care Education at OSPI. Just to let you know, as we get started, I'm here by myself today, so the questions in the question box, I will try to keep up with them. But if I can't, or if I miss something, I will take them back, respond in writing, and then send them out to the group. Okay, so when we talk about the foster care provisions, both in state and federal law, we are fortunate enough that our definitions actually align with the definitions that Children's Administration uses for foster care. So our guidance, the state law, federal law, all say that really when we're talking about foster care, we're talking about kids who are in 24-hour per day temporary substitute care. And essentially, these are kids where Children's Administration has care and placement authority over the child. So in Washington State, we have a lot of unofficial foster care. So kids can't stay with their parents because it's not safe to do so, or their parents can't care for them. Grandma and grandpa or aunt and uncle step up and say, okay, you can come and stay with me. But those kids are never officially in the care or placement authority of DSHS. And so those kids could potentially be in doubled up situations. They are most certainly unaccompanied because they're not in the presence of a parent or guardian, but they're not necessarily in official foster care. It can also include the period of time needed to transition a kid back home after they've been removed. So DSHS maintains care and placement authority over the child when they go through the placement process of putting a kid back in their own home with their parents. And so it's kind of a trial period. What we know is that this is can be a pretty unstable time. And so, you know, best practice would be to continue to serve kids during that period of time while they still meet the definition, even though those kids are placed in their home. So in our state, we have a data sharing arrangement or agreement with Department of Social and Health Services, Children's Administration, and essentially the way that it works is that DSHS sends a data file to OSPI. We then try to match those kids in our student information system, and we push those lists out to school districts. So you should be able to ask your CEDARS administrator in your school district to run the list, and you should get a relatively accurate list of kids in foster care in your school district. There is a verification process, and so because we can only match name, date of birth, and a couple of other indicators before we send that out. So we ask the district to verify that information, verify those kids are enrolled in your district, and then send that information back to us through a verification process. Student information can help you through that process if you're not familiar with it. Also, the child nutrition program in your school district has been doing this for some time, and so they're very familiar with how that works. We get a nightly data feed, and so that information is pushed out to districts on a continual level. So you'll want to make sure that, or a continuing basis, so you'll want to make sure that your foster care liaisons are checking that list often to see if there are any updates. There is, however, a lag. So a kid could come into care yesterday, right, and they haven't been updated in the system. And so they may not show up on the list. So this list through CEDARS should not be the only form of verification the district uses to determine services. If you suspect a child is in foster care but they're not on your list, then you can call DSHS, Children's Administration, and they can verify for you whether or not the student is in care. So I can't really cover federal law until I cover state laws in general, because in our state we have relatively progressive and aggressive child welfare laws that are designed to help kids be successful in school. And so I'm going to cover those first because I think it provides a framework, and the ESSA foster care requirements really support what we're supposed to be doing in state law. So the first one, districts have been required for several years now to enroll kids who are in foster care in school without denying or delaying that enrollment. Our state law specifically says that the receiving school district has 2 business days to get school records. The new federal law says immediate enrollment, and just like under McKinney-Vento, immediate is not defined, but you go to Webster's, as any good attorney will tell you to do, and it means without delay. And so both state and federal law support this notion that you shouldn't be denying or delaying enrollment for dependent youth because they don't have school records or for any other purpose. This actually happens a lot, and kids are out of school for long periods of time, and so we really want to make sure that we're connecting with Children's Administration to ensure that all of their kids in our attendance area are attending school. So schools are also required to review unexpected or excessive absences and support a student as they try to continue to progress in school. And so districts have an obligation, essentially under state law, to monitor the unexpected or excessive absences of dependent youth and proactively support the youth schoolwork so the student doesn't fall behind. This law also refers to suspension and expulsion based on truancy and says you should avoid it. Based on new state law that was passed last session, House Bill 1541, I believe, school districts can no longer suspend or expel kids for discretionary discipline purposes. And so you'll want to make sure that you cross-reference and become familiar with that provision as well. What I typically tell districts is that this is the one case in which your teachers don't get to determine whether or not they're going to provide work to kids or accept work. So if you can imagine a kid comes into foster care, it used to be that the courts sometimes granted visitation but didn't always do that. Now that's really the standard because we know that maintaining bonds is really good for social and emotional health for kids, right? So visitation is almost always ordered, and other requirements are also ordered at that time. So if the student needs therapy, if they have visitation with siblings, if they have 2 parents but those parents aren't together, that can mean separate visitation at separate locations and separate times. And typically all of those things occur during the school day because it's during the business day. And so while we are encouraging staff, Children's Administration staff, to really think about maintaining kids in schools as much as possible, they also have to abide by those court orders and make sure that visitations and doctor's appointments and therapy and all of those things are being attended to. And so our kids miss a lot of school. So this first RCW on this side, this is a slide specifically about records and graduations, and they pertain to school districts. And so the first RCW requires school districts to release records when requested as part of an investigation conducted by Child Protective Services. So what the law says is that any mandated reporter who has records applicable to an investigation are required by law to release those records. And so if Child Protective Services is conducting an investigation and they request school records, the school district must release those records. School districts are also by state law required to transmit education records to DSHS. And so the timeline is DSHS has 10 days from the time a student comes into care to request education records, and the school district has 2 business days to respond to that request. The reason for this is because the courts require a health and education screening tool to be submitted as part of the dependency case, and those CHET screeners, they're called, are required to have certain documentation from the school in order to complete that report, but also to supplement the report that they turn in. So you'll want to make sure that you have a system in place, and you'll notice that the RCW doesn't say only from September to June. So districts need to really come up with systems so that Children's Administration can hopefully have as much year-round access as possible. This next RCW about on-time grade level progression and graduation requires school districts to facilitate the on-time graduation of a foster student or student in foster care, and it says specifically that you should have policies and procedures that combine a suite of services that are available to kids. So the first option is waiving specific courses if similar coursework is completed in another district. The best example of this is Washington State history. So let's say you have a kid who comes into foster care and they're here through interstate compacts, so they come from the state of California. It's pretty much guaranteed that a kid in California is not going to have Washington State history as part of their educational background. And so a school district could waive Washington State history because they've completed similar coursework in another district. A district can also provide an alternative means to complete required coursework. So that could be supplementing with online education, that could be increasing classroom hours, it could be providing supplemental supports. Excuse me. Districts can consolidate unresolved coursework and provide opportunities for credit accrual. And that's something, you know, our kids come into the classroom a lot of times, particularly kids in foster care, where, you know, they're severely credit deficient. And in order to promote on-time grade level progression, it's really the duty of the school to figure out how we can help them catch up on their credit accrual. So sometimes online education is the best way to do that, or a combination of classroom hours and online education. What we don't want is that for a kid to be pushed out of a brick and mortar school because it's easier, right, to provide online education. So it probably needs to be a combination. For some kids, online learning makes a lot of sense, and for other kids it doesn't, so you want to make sure that you're doing what's in the best interest of the kid. And then facilitating the graduation from the sending district where graduation requirements were met. So if I'm a senior and I've already met my course requirements from the school district that I came from, school districts have the opportunity to waive their own graduation requirements and accept the graduation requirements from the sending district. Children's Administration also has some education-specific RCWs that should be noted. One requires that an educational liaison for students in grades 6 through 12 is identified at each hearing in the dependency process. Most often, this is the biological parent, but in some circumstances, the bio parent cannot participate in that role, or they may not be the best person to have that role. And so the court has the option for kids in grades 6 through 12 to identify an education liaison for kids. That person has educational decision-making authority. They can attend IEP meetings, they can sign documents, all of those things. As far as who is an educational decision maker for a kid, that can be the biological parent, the foster parent or caregiver. It could be the caseworker, or any combination of those folks. And so clearly coordination and really understanding the nuances of a kid's case can be critical to making sure that you have the right people at the table. What I will caution you against is that what I've heard from the field is that there's this kind of freezing out process for biological parents when their children have been removed by CPS. And as schools, those parents still have rights under FERPA. They still have educational decision-making authority and should be included in the process. So Children's Administration also has placement. They have a policy of educational continuity in general. So the default for kids in foster care in our state should be remaining in the school that they were enrolled in when they entered care. So educational stability has been a priority for our state legislature for several years now. And this is specific to the policy of Children's Administration as the department. This RCW will come in handy as we have conversations about using Title I money to serve kids. So it basically describes what the primary functions are of Children's Administration when a child is removed from home and that child is school age. So you'll notice it says the department shall. So they must provide youth residing in out-of-home care the opportunity to remain enrolled in school, in the school he or she was attending prior to out-of-home placement. So again, this is school stability is the default. And it says specifically, unless it's not safe for the kid to do so, a relative or another person is secured for the youth, and maybe that makes it not appropriate for the kid to stay there, or it's determined to be not in the youth's best interest to remain enrolled in the school he or she was attending prior to out-of-home placement. And as far as parties to the case, so if, let's say, the parent and DSHS, Children's Administration, disagree about what's in the best interest of their kid, and they're trying to determine where that student should go to school, this RCW specifically says that parties in a dependency case disagreeing need to go before the court, and the court will resolve the issue. Just so you know, by the way, on this slide as well, foster parents are not a party to the case. And so it would really need to be a disagreement between the caseworker and the parent. The second half of this RCW is one of my favorites. It says, unless otherwise directed by the court. So unless there's a court order saying that Children's Administration does not have these responsibilities. The responsibilities are, they need to collaborate with schools, they need to include schools and family team decision-making meetings, notify the receiving school and the school of origin that the kid's in care or that their placement is changing, request and secure missing academic records, although that's now a responsibility that's shifting to schools, document and request receipt of academic records. This one in red is my favorite. It's to pay any unpaid fines or fees due by the youth to the school or school district. So that's for any child in care. If they have unpaid fines or fees, then you can approach the caseworker or the education lead in that region, and you can ask for payment. The fines do not have to be accrued while the student was in care, but DSHS will only pay them while the student is in care. So if you wait until after the kid has exited foster care, it's no longer their obligation to do so. So this leads us into federal provisions. The first one, the Fostering Connections Act of 2008, applies to child welfare agencies. And what it says, and for the first time in 2008, I believe it's the first time, a federal law for child welfare agencies said, hey, if you have kids in foster care, they should probably be in school full-time. And that was like a big deal. It wasn't very long ago, maybe 15 years ago, that the policy of the department was to move kids every 6 months because they didn't want them to develop attachments with caregivers. And so we have had a very fast evolution in a pretty massive system in a short amount of time. But in 2008, they said, hey, kids should probably be in school. It requires that a case plan include a plan for ensuring educational stability. So every time a kid comes in care, one of the things that they have to do, besides ensuring health and safety, right, is that they need to have a plan for educational stability and document why it's not in the kid's best interest to remain in their school of origin if that's the case. They also have to have an assurance that each placement takes into account the appropriateness of their educational setting and the proximity to school. The challenge for us in our state is that we're about 3,000 foster homes shy of where we need to be to meet capacity. So what that means is that caseworkers are having to go farther out from proximity to the school because they're searching for a home where a child can be placed. We just don't simply have enough beds. They also have to have an assurance that the child welfare agency has coordinated with the school district to ensure the child has remained in school. And if remaining in the child's school is not in the child's best interest, an assurance that the child will be enrolled immediately in a new school and relevant records and other records are obtained. The reason that this is a big deal is that with the amendment of the Elementary and Secondary Education Act from the Every Student Succeeds Act in 2015, we now have sister legislation that requires these same requirements. The Uninterrupted Scholars Act of 2013 is also important to note here because what it did is it created an additional FERPA exception for caseworkers, caregivers, and other folks in the child welfare system so that they could more easily access school records. So the Elementary and Secondary Education Act, as amended by the Every Student Succeeds Act, did a few things that were important. It did many things that were important, but for the purposes of foster care, it did the following. So it removed awaiting foster care placement from the definition of homeless children and youth in ESSA, or in McKinney-Vento. So awaiting foster care is no longer part of the definition of homelessness as it applies to public schools. State education agencies, or OSPI, has to designate a point of contact for child welfare agencies. That's myself. The law specifically says that at the state level, this person cannot be the McKinney-Vento coordinator. So I work very closely with Melinda Dyer, and we coordinate services, but Melinda could not serve both functions of foster care, point of contact, and McKinney-Vento state coordinator. It requires school districts that receive Title I Part A funds to designate a point of contact for the local child welfare agency. And there's a condition here that says if the local child welfare agency notifies the school district in writing that it has a designated point of contact for the LEA. In our state, essentially, I sent out notice to school districts that, in fact, statewide, we have child welfare contacts that are corresponding to local points of contact. So in our state, I have a counterpart at Children's Administration at headquarters, and then there is an education lead in each of the DSHS regions, and many of them are establishing primary contacts at local Children's Administration offices, so that there's an appropriate pathway to finding somebody that has the right answer. State plans have to describe collaboration with the state child welfare agency to ensure foster youth remain in their school of origin. So we've been doing that work here, and it's probably important to note that I do speak in the third person about my department, but my department is made up of me. So I think a friend of mine would call that expectation management. So just know that I'm it. And state report cards, for the first time, must disaggregate graduation, discipline, and academic achievement data. And I'm actually really excited about this. When I was hired to do this job, I was told that actually the legislation that funds my job states that my primary duty is to make Washington State a national leader in child welfare academic outcomes. And part of the issue with that is that we haven't established our baseline yet. And so we're very close to being able to establish a baseline to know where we're starting from so that we know what areas specifically we need to work on and where we can improve, and also what we're doing really well. So implementation for the ESSA requirements was December 10th, 2016. That was a Saturday. So up until December 10th, kids who were awaiting foster care were qualified as McKinney-Vento eligible. Those children and youth remain eligible for McKinney-Vento services through the remainder of this year, because McKinney-Vento very clearly says that kids are eligible the entire time they're homeless and until the end of the academic year in which they become permanently housed. And so if they were identified prior to December 10th, they remain McKinney eligible through the remainder of this year. And then next year, if they're still in foster care, then they would receive services under the Title I provisions. If they were identified after December 10th, then they qualify for services under the Title I provisions only. So our state plan needs to describe the steps we're going to take as a state agency to ensure collaboration with child welfare and to ensure educational stability for children in foster care. And so these assurances essentially say that as a state education agency, we're going to develop policies and procedures to help maintain kids in their school of origin when it's in their best interest to do so, help districts establish protocols so that at the local level there's some predictability, and it's my responsibility essentially to oversee the implementation of the state responsibilities. This is an abbreviated job description specific to my federal duties. The first one, monitoring local education agencies or local school districts. I don't know what this is going to look like yet. I'm working very hard to develop a process that is the least cumbersome for school districts that I can manage. And so I am very cognizant of the fact that that monitoring can be a tremendous burden. So while we want to ensure that kids are getting services and that our outcomes are improving, I also want to make sure that it's district friendly so that we can move forward in partnership rather than from a compliance perspective. So we'll figure it out. I'm required to coordinate with a state child welfare agency, which I do on a regular basis. I'm required to establish uniform criteria around best interest determination, and you can find that on my website. I will point to it later on in the presentation, and establish guidelines for transportation procedures, facilitating data sharing with state and tribal child welfare agencies, and providing professional development opportunities for local points of contact. In our state, the state law, or the federal law, I'm sorry, calls out foster care points of contact, but in our state, those folks are called foster care liaisons. So we have 284 out of our 295 school districts receive Title I Part A funds. So many of you probably saw a little box in the Title I Part A application asking you to identify a foster care liaison. That got us to 100% compliance for all of our Title I school districts. And as a state, we actually have 100% compliance with all of our public schools, school districts, and charter schools. There was a word of caution in Department of Education guidance. So you'll remember that I said at the state level, the foster care point of contact cannot be the McKinney-Vento state coordinator. The law does not specify at the local level that that's true. So in many districts, we have the foster care liaison also as the McKinney-Vento liaison. Guidance cautions us, however, because McKinney-Vento specifically has 10 duties listed in law, and it says that liaisons have to have the time and capacity and resources to do their job. And so you'll want to make sure that you evaluate that at the local level before assigning this work to your McKinney-Vento liaison. Because of the heavy collaboration component and the state and federal law combination of requirements, this is a time-consuming gig. It takes some time, particularly the collaboration with the other agency. And so I would caution you against, if you have a full-time liaison already and that person has a full-time caseload, adding this to their duties is probably not the best idea. What I will say is that one thing that is not okay is using your Title I homeless set-aside or McKinney-Vento grant funds to pay for foster care work. You can't do that. You have to leave McKinney-Vento funding and McKinney-Vento Title I set-aside whole. Here are some sample liaison duties. You'll notice that they mirror mine, except at the local level, you want to make sure that you're facilitating transfer of records, attending training as well as delivering training. Melinda Dyer and I are working very hard to make the foster care pieces mirror McKinney-Vento as often as possible so that your district doesn't have to develop additional protocols to do the same work. And so, for example, immediate enrollment works exactly the same as it does for McKinney-Vento. And so anytime you're training registrars on McKinney-Vento, you can say, and kids in foster care. And the processes should be the same. Developing and coordinating local transportation procedures, managing best interest determinations and transportation cost disputes, and ensuring that children in foster care are enrolled in and regularly attending school. So again, here's that caution. I will not be monitoring for this when I do determine what monitoring needs to look like, because there's no provision in my law that says that it can't be the McKinney-Vento liaison. The foster care person can't be the McKinney-Vento liaison. But I know that for the purposes of McKinney-Vento, it is likely going to be a monitoring issue. So here's some tips that the U.S. Department of Education offered to help determine capacity. So data indicating the prevalence and needs of homeless children and youth, which you probably have established in your district. We require you to do a needs assessment, so that's a great document to start with. Past technical assistance provided to the LEA. So is your school district struggling with basic compliance issues around McKinney-Vento? The number of schools and students in the district, and the number of identified homeless students in the district as a percentage of students living in poverty. One way to look at that is when I worked for Melinda back in the day, I did risk-based monitoring. And so what I would do is look at the free and reduced lunch percentage and figure out that approximately 10% of all kids living in poverty are probably experiencing homelessness. And so if you're way under that, you'll want to look at your identification strategies. And you may be correct in your identification, but you just want to make sure that you're doing everything you need to do for active identification. This is an email, text from an email that went out to DSHS caseworkers, reminding them of their responsibilities to collaborate with schools. It was nice of them because they reference a frequently asked questions document that's also on the foster care website. It talks about communicating with schools when children enter or exit care or change placements. And they provide a sample school notification form. This form is not required for social workers to use, but they are required to provide the notification. So if you have a caseworker where you can't get them to fill out this form and send it to you, you can call them and ask them for the information over the phone and fill it out. I believe the sample form, the link to it, actually goes to a Word document, and that will be posted on my website. So school of origin under Title I for kids in foster care is the school in which the child is enrolled at the time of placement in foster care. It's pretty straightforward. On December 10th, the school the child was attending was their school of origin. Any kid who comes into care afterwards, the school that they were attending when they were brought into care is their school of origin. So they need to remain in their school of origin unless it's determined to be not in their best interest. That language should sound very familiar from McKinney-Vento. And I will note as well, whenever there's a challenging definition, school of origin, immediate, those kinds of things, if it's language that's taken from McKinney-Vento, our assumption is that the definition is the same and the application of that definition is the same. If a child in foster care's placement changes, the school of origin would be considered the school in which the child is enrolled at the time of the placement change. So if they stay in their school of origin when they're brought into care, and then their placement changes, that school remains their school of origin. If they change schools due to their placement change, then they would have the right to attend their neighborhood school. Best interest decision-making for kids in foster care should look very similar to that of McKinney-Vento. The difference is that you have another partner in the decision-making process, and that's Children's Administration. Children's Administration has access to the case plan. They know, generally speaking, what the child's permanency plan is. They might not know like the A to B, but they know the A to Z, right? So they know eventually where the child is likely to end up. Reunification is always a top priority, so if there's any opportunity to do that, they will. So you should look to them to develop mutually appropriate best interest decision-making protocol. A hint to you, there's a document on my website called Best Practice Guide to School Selection that has a checklist on the back page, and Children's Administration staff have looked at that and said, yes, this makes sense. So what that means is that you can have a conversation based on that document with Children's Administration staff, and they've agreed that those criteria actually make sense for determining best interest. DSHS should trump a school district considering best interest if there's a health or safety concern. So just keep that in mind. Decisions should be made using child-centered criteria. Transportation should only be considered in the context of the impact it has on the kid. So there's no district line, no county line, no state line, no mileage limit. This is a federal law, so there literally are no boundaries. So there's no time or mileage limits, and so you really want to look at what is in the best interest of this particular child and youth. I had two boys, one of which could ride in cars for a long period of time, and one I wouldn't sit on a bus for more than 32 seconds because it was just a really bad idea. So it really depends on the kid. You might make different transportation arrangements for a high school senior than you would, an elementary kiddo. It just kind of depends. Going back, because I just reminded myself of something, the school of origin, and I just forgot it, sorry. It's hard to talk to yourself for a length of time. If it comes back to me, I'll share it with you. So for transportation, back to school of origin. Okay, so the definition of school of origin in McKinney-Vento changed this year to include free schools if they're district run or administered, and feeder schools if the school is part of a standard feeder school pattern. So everyone from McKinney Elementary goes to Vento Middle School. So again, applying McKinney-Vento definitions to the foster care provisions, we can assume that school of origin also includes that new definition of school of origin. Okay, so transportation. The law says that a school district receiving Title I Part A funds needs to collaborate with Children's Administration to ensure that transportation for children in foster care is provided, arranged, and funded, and that's specifically from the law. Our procedures that we develop must ensure that children in foster care needing transportation to their schools of origin will promptly receive that transportation in a cost-effective manner. Cost-effective manner is language that comes directly from the Social Security Act because it's a requirement for Children's Administration in their use of federal funds to ensure that what they're doing is the most cost-effective they can come up with. And so cost-effective manner was added to the education statute to ensure that Children's Administration could, in fact, collaborate effectively with the district. If there are additional costs incurred in providing transportation to the school of origin, the school district will provide such transportation if. So if there are no additional costs, the school district needs to provide the school of origin transportation. If there are additional costs, the school district will provide transportation if. Those two ifs are very important. So if there are additional costs, you need to provide transportation if Children's Administration agrees to reimburse the school district for the cost of such transportation. The school district agrees to pay the cost, or the school district and the local child welfare agency agree to share the cost. So additional costs, if you read through the foster care guidance, has a specific definition, but it's not appropriate for Washington State because we have a very different transportation funding formula. It's unique because it incorporates transportation funding as part of our basic education allocation. And so if your school district, there are 122 school districts in our state currently that are funded at 100%. Billing to Program 99, a district that provides McKinney-Vento or foster care transportation can receive up to 100% payment for providing that service, and it's direct cost. It's not based on ridership. So those school districts that receive 100% of their funding covered will not incur additional costs. The state pays it for you as part of your basic education allocation. For the remainder of the school districts, if you have additional costs in providing transportation for a kid, these conditions have to be met in order for the district to provide that transportation. We've developed a statewide dispute process that has an expedited process on the back page for interagency disputes. So disputes over determining best interests, maybe you and DSHS don't agree, or sharing costs. So in our state, districts must provide transportation while disputes are being resolved, whether that's best interest. I did put a provision in the dispute resolution process, however, that either party could file the dispute. So under McKinney-Vento, it's only the person that's not getting what they want, right? The parent or youth can file a dispute. In this case, for that interagency dispute, a school district could initiate a dispute as well, but they need to provide the service while that dispute's occurring. It's expedited. It's a very short time frame. It doesn't go through a local process. It comes directly to the state, to myself and actually my colleague at Children's Administration. We've mutually vetted that dispute resolution process and agreed that that's what we'll use to determine whether or not services should be provided. And just remember, do not refuse service and don't stop services while the dispute's occurring. The kids should never know that the grown-ups can't figure it out, right? So you want to make sure that the kids getting to school, they're stable, and that the district is practicing due diligence to ensure that the child is as stable as possible. So the guidance says that transportation procedures should include dispute provisions. States were encouraged to develop uniform state dispute processes, which is why I developed the statewide dispute resolution process, and asked Children's Administration to vet that process so that we could use it with both agencies. And the school district needs to provide transportation while disputes are being resolved, and that comes from non-regulatory guidance, but suggests that we should do that as practice. And in all honesty, it would be very difficult for me to ensure compliance if we didn't have the provision where districts needed to provide the service before they're told that they don't have to, if that makes sense. So for enrollment, remember that enrollment means attending and participating fully in school activities. This includes extracurricular activities, academic and non-academic, so kids don't have to just stay after school for some math tutoring. They could also stay after school for band or for music, choir, or for an athletic event or athletic participation. They're also categorically eligible for Title I and free meals. So your child nutrition department should already have these kids vetted through their direct certification process, similar to the foster care list that you can access through CEDARS. There could be a lag, and in that case, the foster care liaison could provide documentation to the child nutrition office, similar to that of McKinney-Vento, to say, yes, this kid qualifies for services. School districts should ensure that children in foster care are regularly attending and fully participating in school, and that their educational needs are being met. And while this is a federal provision, it is also true under state law. We have the duty to do so. School districts, state education agencies and school districts also need to take affirmative steps to revise policies that are barriers to enrollment and attendance for kids in foster care. So immediate enrollment, we talked about the definition of immediate. It doesn't exist in law. However, Webster's Dictionary says immediate means without delay. And so the same process for immediate enrollment that is true for McKinney-Vento kids, you would also want to apply to all children and youth in foster care. And that's not just putting them on the books, that's also they're in a seat, they're participating fully. Enrollment must not be denied or delayed because documents normally required for enrollment have not been provided. This is the same as under McKinney-Vento. We still get questions and concerns from school nurses or from other folks who say, yeah, but the kid has a chronic health condition, so we're not letting them come to school. Under federal law, which trumps state and local policy when they're in conflict, kids need to be enrolled immediately. And that's without immunization records, that's without health plans. You have caseworkers. In the case of kids in foster care, you have caseworkers who can help you develop those plans quickly, but you want to make sure that they're in school. Also, discipline, you want to make sure that kids are enrolled immediately. So Title I Part A, Categorical Eligibility. This works similarly to McKinney-Vento. So you could have kids who do not meet your standard Title I requirements for eligibility. However, they're categorically eligible under the foster care provision. So if they don't attend a Title I school or they need services that are outside of the kind of standard services you provide under Title I, then you need to develop a system where kids can get their academic needs met based on their actual needs. So if they need services in an area that's outside of reading and math, for example, let's say you have an advanced placement history student who goes into foster care and their grades start to slip, the school can provide Title I tutoring in order to help mitigate the impact of foster care and keep that kid up to where they were performing. Not every kid's going to want to do that, and the school in partnership with the student and the foster parent or the caseworker should really be the ones who are determining whether or not it's needed. There are some funding limitations. Remember that RCW I told you about, where DSHS is required by state law to pay fines and fees for kids in foster care. That means that Title I funds probably shouldn't be used to pay fines and fees for kids in foster care, right? There are some situations in which a student may want to participate in an activity, or you can't kind of track down a caseworker or a foster parent in a timely fashion for a school-based activity, you can use Title I funds at that point. Birth certificates, immunization records, medical services are first and foremost the responsibility of Children's Administration. And remember, your home was set aside must remain intact and cannot be reduced or repurposed to serve children in foster care. So I've developed some slides that just have some basic resources to kind of point you in the right direction. I'm trying to develop stuff relatively quickly, although that can be a challenge sometimes. But as I develop information, the first thing I do is I put it on the website so that you're constantly updated with stuff that you need to know. So this is the picture of our website, my website. This right here is where you can sign up for email and text alerts specific to foster care. So it's a Gov Delivery newsletter. Anything I send out to a school district in bulletin or memo, a bulletin format, also goes out on Gov Delivery. The idea being that it's helpful for everyone to get the same information, so there's not the translation issue. But also, it's a good way to stay up to date because things are changing rapidly. In the last 9 months, our implementation strategy has changed dramatically just because we know more now than we did then. This is where you'll find the foster care liaisons and DSHS contacts. So those education leads that I told you about, they're listed here, along with the counties they serve. This frequently asked questions tab, I'm not quite sure why it's called that, but it is. This is where you find all the technical assistance materials. So that 21-page frequently asked questions document, as well as sample forms. I'm in the process right now of developing a sample dispute resolution packet for districts to use with folks who may want to dispute some decision making. And so that will all be available there. And this is my contact information. You'll notice on the right-hand side I have questions and then fostercare@k12.wa.us. It would be awesome if you have either a general technical assistance question or something that's not intended for me personally. I guess that's the best way I can put it. If you could email the foster care email box, I'm trying to route all my technical assistance and questions through there because I have a new method of documentation that will allow me to streamline responses. So this is what the Gov Delivery newsletter looks like. This is where you update your contact information for your liaison. Don't go in and do that for your friends. This is a map I'm working to develop with Kathy Walker, who's in our transportation department. She does GIS mapping. And essentially what this is every purple dot represents a foster care liaison and is associated with a school district, as you can see on the map. The color coding is based on DSHS region, so that's hopefully helpful. And then you would click on one of those school districts or a region, and all of the resources that are available for kids in foster care that are captured would pop up in that pop-up box. So if you have independent living providers or a program called Setup or a Treehouse Graduation Success, or every region has a Treehouse Education Advocate, the foster care liaison information, all of that will pop up in that one box. So it's really a one-stop shop for the information that's appropriate from a geographical perspective. This is the frequently asked questions document. That school selection checklist I was telling you about. It provides some guidance on the front page about how to have those conversations and then the checklist on the second page. the dispute resolution process along with the flow chart. The timelines of the dispute resolution process for the local piece are identical to McKinney-Vento. Again, we didn't want districts to have to recreate a completely new process in order to implement this. So there are some nuances that are different. After about a decade in McKinney-Vento, I took Melinda's dispute resolution policy and changed it so that it reflected the new provisions under McKinney-Vento because it needed to shift a little bit. So it applies also to services, not just attendance. And also I just changed some stuff that was irritating. And this is my contact information. So if you have any questions or concerns, or you know, I can help with just about anything related to foster care. So, and if I can't, then I will attempt to find the person who can. And my screen went actually black with the questions on it, so I'm not going to respond to any of them verbally now, but I will respond to them in writing in probably a couple of days. So thank you very much for your time, and I appreciate you hanging in there with me.